specializes in complex business litigation and intellectual property, particularly copyright and trade secrets. He did his undergraduate education at Stanford and got his JD at University of Chicago in 1998. So, let's welcome him.
Hi, wow, that's loud. Okay, good afternoon. As you just said, my name is Michael Risch. I'm happy to come talk to you today about why we have trade secrets. In some respects, it's kind of a misnomer. We have trade secrets because somebody sometime thought it was a good idea, and now they're lost. So the real question is, why should we have trade secrets? And believe it or not, there are people who think the trade secrets are overextended, that they shouldn't be around, that they should be cut back. And really the purpose of this article was to take issue with that. I just learned that you guys learned a little bit about trade secrets as property in your 1L property class, which is surprising to me, considering that there's actually debate about whether or not trade secrets are property, and we can talk about that. My plan is to talk for 15-20 minutes about some of the ideas that I put forth in the paper that I'm publishing, and then to take questions. However, if you have questions before that, please raise your hand, let me know, stop me. If I say something that doesn't make sense, or if I use a word that I haven't defined, please tell me, because I want to make sure everybody's following along. The first question I have is, I want to make sure we're all on the same page about what a trade secret is. Raise your hand if you, well, let's start this way. Raise your hand if you've heard of trade secrets. Okay, that's about everybody. Raise your hand if you know how a trade secret is defined. Okay, so let's start there. A trade secret is information. It's as simple as that. It's information that has independent economic value because it is secret. Typical trade secrets, the secret formula for Coca-Cola is a pretty famous one. They have special rules about who gets to know it, who doesn't get to know it. It's broken up. That's something that they don't want to get out. But trade secrets can be as mundane as a customer list, peculiar preferences of customers. I know that customer X likes bagels delivered on Friday, so when I make a sales call, I'm going to bring them bagels because that's how I close deals. That can be considered a trade secret if it's something that has value to the company and is not known to the general public. There are other rules about trade secrets, namely, the owner of the trade secret has to take steps in order to keep the information secret. If you don't try and protect your trade secret, you can lose it. And finally, whether or not you're liable for misappropriation of trade secrets depends on how you get the information. If you stumble upon it inadvertently, you're not really a trade secret misappropriator. However, if you obtain it by improper means, for example, if you use fraud, or if you are an employee and you breach a contract, or if you commit espionage, that is considered improper means. So the question is, why do we want to protect this particular type of information? And why do we only have liability under certain circumstances? For example, why do we allow reverse engineering? Before I get into the whys, I'm going to start with an easier question. Why do we care? Why do we care about whether we have trade secret law? Why do we care why we have trade secrets? The simple answer is that trade secrets are really, really important. They're really well litigated. I personally litigated many trade secret cases, some in trial, many settled before trial. And there's data to show that they're at least as important as patent law as far as the number of cases. And by the way, some of the questions I'll take after, if you have questions about practice and intellectual property, etc., I'm willing to answer those as well. So given how important they are, we want to know why we have them for three primary reasons. First, we want to shape policy about trade secrets. We don't want to overprotect them. We don't want to underprotect them. There is a concern that if trade secret protection is too strong, that you will essentially keep competitors from using information that should be free and public to all. For example, what if the phone book were a trade secret, all the names and numbers? That would lead to absurd results. It would mean that nobody could do business by looking into the phone book. And therefore, if you gather names and information and phone numbers that are available in a phone book, you can't protect it. If we understand why we have trade secrets, we can shape policy. Number two, to the extent there are people who want to get rid of them, if we understand why we have trade secrets, we can justify them in a debate. And number three, if you understand why you have trade secrets, you can make an argument to a court who would not protect them. And in fact, the article starts off with a case I had last year. We were sitting in judges' chambers. It was a trade secret case. An employee had stolen about 50 pages of source code, copied it almost directly. And the judge asked, well, I assume you'll have evidence of irreparable harm if you show trade secret misappropriation for me to enter a permanent injunction. And I was thinking, well, isn't that why we have trade secrets? If you misappropriate, you get an injunction. Isn't that how it's supposed to work? Why should I have to show irreparable injury? If a guy pays damages, he'll probably go out of business. So does that mean you can start a new business and use the same trade secrets again? Knowing why we have trade secrets allows you to form an argument in response to questions like that. So I want to look at 4 different reasons why we might have trade secrets. The first is, are trade secrets property? For a lot of people who are strong believers in property, the argument is, well, if you have property, then you should protect it. And in fact, that's probably why you get intellectual property in your 1L property classes. People have inventions, they get patents. That's property, we should protect it. People make music, that's property, we should protect it. People generate secret information, that's property, we should protect it. But there's a counter view to that. And the counter view is, just by calling it property, you extend protection too much. And for any of you in here who believe in fair use or believe that music sharing is a good thing because it allows you to listen to the music first and decide whether you want to buy the CD, you would argue that calling it property is too much because stopping that kind of fair use is not really necessary to get people to make music. That argument, though, doesn't really work very well with trade secrets for a couple of reasons. The first is, one of the basic premises of copyright and patents is that the protection is there in order to encourage innovation. And the idea is, once you have released your copyrighted material to the world, if you don't have some protection for it, everybody can copy it freely. Same with an invention. Once you put your invention in a patent, everybody can copy it freely without protection. This doesn't really apply to trade secrets. And the reason is, trade secrets are going to be kept secret. That's the whole point of them. So even if there was no trade secret law at all, if you had Coca-Cola's formula, I guarantee you they wouldn't publish it. They would keep it secret. And so you can't really use the argument that we're going to overprotect the information, because the information will be protected anyway. The other thing about overprotection of trade secrets is the real nature of the law has not changed in 25 or more years. You see a lot of flux in patent law, you see a lot of flux in copyright law, but how much protection are we going to give? Nobody's debating how much protection we should give trade secrets. It's pretty well settled. And even when the Uniform Trade Secret Act was passed and came out in 1980, it was passed in different states at different times, it tracked basically the trade secret law as it had stood for 100 years before that. It's really not a law where there's overprotection. Even so, we have to look at whether trade secrets are property, because if they are, maybe we want to have injunctions, maybe we want to protect them. And what this article does is separates trade secrets into 2 different types of property when justifying them. The first is collateral property. And collateral property is really something you call property, but it's really not important when the core right is an issue. So, for example, there was a case many years ago. It was about whether or not the FDA requiring disclosure of drug trials or chemical trials was a taking under the Fifth Amendment. And the Supreme Court ruled, yes, trade secrets are property for purposes of taking. expose some. If the government forces exposure of a trade secret, it can be taken. Other questions about property, you can sell them, you can devise them in a will, and this is all the indicia of real property and personal property. However, when you're looking at whether somebody has misappropriated trade secrets, whether somebody's actually committed the tort that the statute is intended to protect, whether or not you call something property is less important. I call that substantive property. So on one hand, we can call trade secrets collateral property. Sure, if it's important to enforce a right. Another example is the California Labor Code says if you generate information for your employer owns it. It's fine to call trade secrets property because you want to shift ownership of them. But if the question when an employee leaves and uses that information, whether that information was a trade secret, well, the fact that it was owned by the employer doesn't mean necessarily there was misappropriation. It might not have been secret. The employer might not have kept it confidential. It might not have been improper means. All those things apply. So instead, what you have to do is you have to look at the bundle of rights that trade secrets are and determine whether or not those are justified in any trade secret misappropriation action. And the bundle of rights flow from the definition of a trade secret. For example, you can use the information. It's not a given. Patents, you don't have a right to use the patent. You don't have a right to exclude others from using it. If your patent covers something that's already patented, you may not ever be able to use it. You have the right to exclude others from using it, but only if they obtain it by improper means. You have the right to stop using it and still protect it. And that actually is another example where there are some differences in the law. For example, think of when Coke put its formula on the shelf and came out with new Coke. When they did that, the question is, does the Coke formula now become fair game? Anybody can go in and steal it and use that formula against Coca-Cola. And the answer is no, you can put it on the shelf and it still remains its trade secret status. So a little later on in this talk, I'm going to talk about the justification for some of these rules. But first, I want to talk about two other ways we justify trade secret law that are not economic-based. The primary justification in the article is an economic-based one. That is, society is better off by having trade secrets than not. But before I get there, I want to talk about the philosophical justifications and populist justifications. I think most people who own trade secrets would follow the philosophical rule. The first one is the lock-in view, for anyone who's looked at lock before, and it's a labor value view. And the idea is if you expend your effort and time and money to develop information, you should own it. It's a natural rights theory that says you should own the fruits of your labor. And if you ask most business owners who have trade secrets, that's probably what they would say is the justification for trade secrets. I worked hard on this, I should own it. Now the problem with that is, number one, you have to really believe in the lock-in view of owning your fruits of your labors. And there are people who don't. There are socialist folks out there. There are people who are a little more Hobbesian. There are people who just don't buy into the natural rights view that you should own the fruits of your labor. And if you don't buy into that, then you don't buy into trade secrets, and that's a problem. The second problem with the philosophical view is it doesn't really justify the very specifics. Why, for example, under the labor value theory, is reverse engineering okay? There's not really a great answer to that. There's no great answer to why it's not okay. There's really no way to get to the fine-grained policy we have. That said, I'm a firm believer that if you generate secret information and keep it secret, you should probably own it. I think most people agree with that, and I think it's a pretty strong justification for trade secrets. A second philosophical view is an original position type theory, more specifically Veil of Ignorance by Rawls. Yes?
Real quickly, could you explain what reverse engineering is? I'm sorry if I
Sure. Sure. There's a term I didn't define. Reverse engineering is, let's say, is where you basically determine information by by looking at a completed object. For example, let's say AMD wants to come out with a faster microprocessor. So what they do is they buy an Intel chip, and then they peel it open, and then they look at the circuit, and then they determine what some of those circuits are doing. That is one form of reverse engineering. There are other forms. For example, video game companies will reverse engineer video games. They're not licensed to use them, but what they'll do is they'll buy a video game box, and then they will put they'll put a little device in between the video game box and the video game, and then they'll look at the signals, and they'll say, aha, when I move the joystick this way, this signal gets sent. When I move the joystick this way, this signal gets sent. And that way you can figure out how the inner workings work without actually without actually doing it yourself, without actually having done the design. And so there are people out there who say that should be illegal. You should not be able to do that. And right now, trade secret law says you can do that legally. So if you can't protect a trade secret from this type of probing, well then, too bad, it's not really a trade secret, or even if it is a trade secret, it's not really misappropriated if somebody uses reverse engineering. That answer your question, I hope? Okay, good. And actually your question about reverse engineering ties very specifically into the veil of ignorance initial position argument that it's kind of a Rawlsian, if you've read John Rawls at all. And the idea is this: imagine yourself before time begins or before any trade secret law is passed, and imagine that you don't know who you're going to be. You don't know if you are an employee, you don't know if you're an employer, you don't know if you're a big company, you don't know if you're a small company. You don't know anything about anything that would be important to making a decision about how information should be protected. And the question is, what is it that you would do? And the basic theory would be, well, you'd want to have some protection for information, because what if you're an employer? You'd want to have some protection because you'd spend your money developing it, you'd want to be able to protect it. At the same time, you wouldn't want to protect it too much, because what if you're a competitor and you want to reverse engineer? Well, then you should have some reverse engineering. Or what if you're an employee? You don't want to be barred from working by trade secret law. And so the idea from the original position view is, if you didn't know who you were going to be, you would probably agree to a system where there was some protection, but the protection didn't stop you from moving as an employee to another company, and the rule would not stop you from using fairly obtained information without any kind of wrongdoing. And that's another philosophical view, and I think a lot of people buy into that. So each of those, I think, are good explanations of why we might have trade secrets, although even then, once again, we don't have the fine-grained analysis. The next reason why we might have trade secrets... Sorry about that. No question. The next reason why we might have trade secrets is a more populist view. And that's what I started at the beginning. We want it because people think it's a good idea. And there are kind of two things to think about with this. The first is, to the extent that trade secrets have been justified by enforcing commercial standards of decency, which is what some courts say, that kind of falls into the populist view. It's not a great philosophical explanation. It's not a great economic explanation. But people just don't like bad acts. And so we want to stop people from stealing trade secrets, and that's a good reason for it. The other thing about the populist view is it's not federal law. A lot of people complain about federal intellectual property, copyright and patents, that they're captured by special interest groups, etc. But trade secrets are at a state level, and they start with the courts. So there's a lot less argument to be had there that there's some special interest group that's driving trade secret law. And thus really is more populist than kind of a public choice argument where you've got big business driving trade secrets. That's a very short section of the article, but I think it is an interesting point that people, because we have 50 states, they all have trade secret law, there's got to be some justification, because there are very few statutes that are around in all 50 states. You've got some of the uniform codes, uniform commercial code, family codes, etc. There's a lot of other things that are not agreed to by all 50 states, even though they're good ideas. So the last area I want to get into is the economic justification. And it's interesting because the economic basis for trade secrets is one you would not expect. And it's one that's different than other intellectual property. It's not the incentive to innovate. The first thing I want to make sure, though, is when we talk about economics, we're talking about the marginal value of any rule. And by marginal value, what I mean is you take the status quo and you look at the difference any given rule makes. And the reason why it's important to look at the marginal value is the same reason why you've got questions about whether trade secrets should be property or not, or whether innovation should be encouraged, and that is people are going to keep the information secret anyway. So if that's so long as you don't have a forced disclosure rule, I guess the alternative could be to let people walk through factories, or if you come up with secret information, you have to put it in the newspaper. As long as you don't have that rule, and I don't think we ever will, people are going to keep information secret. And so long as information is secret, when we look at trade secret law, we have to say, what will the effect be on the people who are already keeping information secret? And so let's look at some of the rules of trade secrecy and see what effect they have. First rule is only some information is protected, and that's information that has independent economic value from being trade secret. And this has an important feature in law, and it's a practical feature, and that is it's a signal to the court that there's something worth fighting about. Imagine if you tried to claim the phone book as your trade secret. You ran into court and you said, Your Honor, the phone book is my trade secret. The court would say, get out of here. That doesn't have any unique value to you. You're wasting my time here. And so only having information that's valuable stands as an important reason why we have trade secrets. But I want to get on to the next one, which is that we don't require more than reasonable efforts to keep information secret. I mentioned before in the definition that employers have to use reasonable efforts to keep their information secret. And there's value in that too, we can talk about. But more important, I think the heart of trade secrets and why we have them is that it doesn't require more than reasonable efforts. Let me give you an example. I have a client who has an office in China. They have an office here, they have an office in China. And he was bragging to me about all the security features that they put in China. They got like retina scans on the door, and they don't have floppy drives anywhere, and no USB keys are allowed, and they got super duper alarm systems and video cameras and like 24-hour security, and they've got a firewall that examines all the information as it goes out over the internet to make sure that nothing goes out, and email is limited, and he's very proud of this, and they spent a lot of money on it. And the question in my mind is, would you spend that much money here? And the answer is no way. That is just so much overkill to protect the information. And let's look at the reason. He has a perception, I don't know if it's true or not, I think it's probably true, that in China, he can't protect that trade secret. There's no court he could go to get some protection. He can't get recourse. Once it's out, it's out. And therefore, he spends a lot more than would ordinarily be reasonable in order to protect that information. Here in California, where I've actually done trade secret cases and collected damages and gotten injunctions for the very same trade secret information, they still have some protection. They still have monitoring, and they have non-disclosure agreements, and they have a card scanner to get into the, an ID card to get into the main work area. They don't spend nearly as much, and that is a critical feature of what trade secret law can do for you. It keeps people from spending way too much money on protection inefficiently. There are lots of other ways. For example, a business might be a family business. If they don't have trade secret law, they only employ family members. Or they do what Coca-Cola does because their view of life is no law can protect them from the harm that would come if their formula got out. Only certain people know the formula at any one time. no fewer than 2, no more than 3. And they only know parts of it. So if somebody gets hit by a bus, the other 2 people can put it together. It's like, it's a little bit of redundancy, but not too much. It's a very inefficient way to run a business, because they're all, oh, and I guess they have to have a rule that they can't all be, it's like the State of the Union, they can't all be at the same place at once, because if all 3 of them go down in a plane crash, nobody knows the formula of Coca-Cola. That is not an efficient way to run a business. But the value of the information to Coca-Cola allows them to do this. In general, we have trade secret law as a backstop, so we don't spend that kind of money. The next question, though, is why do we require any efforts at all? If it's true that you can collect if somebody misappropriates your trade secret, why do we want companies to even spend card key scanners? Why do we want them to take any efforts? And there are 2 ways to look at this problem. The first is from the marginal cost point of view, and that is, if we didn't have trade secret law, what would happen? Well, they'd probably take some reasonable steps to protect those trade secrets. Therefore, there's not really a marginal cost to that rule. The same with or without the law would apply. But secondly, we don't want to overprotect information. What we worry about is that employers will waste the court's resources by suing people for an inadvertent disclosure of trade secrets. For example, let's say a company's got a customer list, but they don't tell anybody it's secret. They don't tell anybody to keep the phone number secret. They employees email this list all over the place. They email it to their friends. They post it on the website. And then an employee leaves, starts a new company, and starts calling the same customers. And they get sued for trade secret misappropriation. And believe me, stranger things have happened. And the answer is we don't want to waste the court's time and resources having companies sue employees who had no idea the information was secret, who could never have known it was secret, and when the information was inadvertently lost. Because the problem is, if it's published on the website, how do we know the employee didn't just leave and then look at the website? So now I want to move to the other half. I've talked a lot about protection of trade secrets and kind of some of the benefits. The primary benefit being no overspending on protection, and look at what it takes to show misappropriation. And what it takes is improper means, as I said before, breach of contract, fraud, espionage, etc. And the reason for that rule is much the same as the reasonable protections rule, because some people call it the arms race. Improper means implies I spent some resources to get it, and not always. But I spent some resources to get this information, and we don't want wasteful spending on getting trade secrets. So, for example, there was a case about a company that flew over and took aerial photographs of a plant that was being built. The idea is we don't want to allow that, because all that's going to do is make the company who's doing the building put a big tarp over. And then once they do that, then the other guys bring in the thermal satellites, and then we need, I guess, on the tarp we'll have to put a bunch of ice packs so that you can't see through it. And it's absurd, right? You're chuckling because it's funny, because it's absurd and it's costly. But people would do it in order to get the information if there was no recourse. So here's what we do: we say, look, the misappropriator, get a choice. You can decide how important this trade secret is to you. If it's so important that it's worth getting that thermal satellite out, then by all means do it, but you're going to have to pay for the damages for misappropriating that trade secret. And and built into that is the risk of getting caught and the risk of attorney's fees, etc. And the misappropriator gets to decide how important is this information. If it's like make or break, if it's $1 billion, then we'll spend $1 million. But the problem, of course, if it's worth $1 billion to the misappropriator, it's probably worth $1 billion to the person trying to keep the secret. And so really what the rule does is say it's got to be worth more, sufficiently more, to the misappropriator than to the trade secret owner in order to justify its being taken. If I've got secret information worth $10, and my competitor could make that information worth $1,000, and all they got to do is spend $100 on, all they have to do is spend $100 on the action of misappropriating, then maybe it's worth it. Even this, though, gets complicated because there's additional rules to really stop that kind of behavior in the trade secret law. Two general rules. Number one, you get the benefits, the unjust enrichment of this trade secret theft. So if something is worth $100 to the person who takes it, then they have to give that $100 back, plus, or $90, plus they have to give the $10 that was damaging to the property owner, the trade secret owner. See, I even slip into calling it property. Also, you've got punitive damages, you've got attorney's fees. All these are additional costs designed to deter the misappropriator from spending money on taking the trade secret. Because if the misappropriator is not deterred, if they want to spend money taking, then the person who owns the trade secret will spend money protecting, and they'll spend money protecting up to the value of the trade secret. Sometimes even more if they're risk averse. And what that means is you have this arms race. And so that's why you see some pretty stiff penalties under trade secret law. It's not because we want to protect trade secrets as property. It's not because we want to protect innovation. It's really because we don't want a world where people spend a whole bunch of money trying to steal secrets rather than trying to redesign themselves, because there's a lot of value in redesigning. So I've talked more than 20 minutes. With that, I'll wrap up and see if anybody has any questions either on this or about practicing IP law in the area, or any of the things I said, etc. Yes?
I had one about if there are any, I was wondering if there are any significant differences in trade secret laws among the states. I mean, it's controlled by a state.
Depends on how you define significant. There are two different types of, there are three different types of states. There's Uniform Trade Secret Act Flavor A, there's Uniform Trade Secret Act Flavor B, and then there is a few states, and they're big ones like New York and Texas and Massachusetts, who still follow the old restatement rule, which is the common law. The restatement was from 1939 or so. So here are the primary differences. Under the restatement rule, if you stop using a trade secret, it's no longer protected. So if Coca-Cola's in Massachusetts and they stop using the trade secret and somebody goes in and steals it, they might get punished for breaking and entering, but there's no trade secret misappropriation because you weren't using the formula. And this, of course, assumes they're not using it anywhere in the world. Maybe they still sell it in Europe with that formula, although if you know formulas differ everywhere. So that's one primary difference with the restatement. The Flavor A and Flavor B goes to an interesting question that's in the article but I didn't discuss about readily ascertainable. The Uniform Trade Secret Act defines a trade secret as an information that is not readily ascertainable. So, for example, you can't see it via reverse engineering. California and a couple other states do it differently. They say even if information is readily ascertainable, it can be a trade secret, but it's a defense if you readily ascertained it. And this comes up a lot in California. In fact, I've had at least 2 or 3 trials where this was an issue. The idea is this. It's like we claim a trade secret in how our software works, features and functions. We only sell it under NDA. An employee goes out and takes those same features and functions, makes a competing product. They say, hey, wait a minute, look, I did this web search, and site A says you do this, and site B says you do this, and if you only spend 10 or so hours, you can gather up all the features of what your product does. In some states, you would say, well, then the product features can't be a trade secret because those features were readily ascertainable. California goes a different way, and I tend to agree with this rule. California says, look, if you can show that you actually went out and spent that 10 hours and gathered up the information, then fine, that's a defense, you didn't misappropriate. But if you didn't, and you just took the information and used it, well, then you're still liable. So those are some of the three big differences. There's some other minor ones, but for the most part, trade secret law is very similar. There are other questions about whether or not you have to have a trade secret in order to enforce a non-disclosure agreement. That's one difference. So, does that answer your question? I don't. Your question?
I guess I just wanted to come back to reverse engineering. And
Sure.
kind of what rationale the court offers for that exception, because it seems like it's no different than getting emailed the schematics for whatever, chip that you're breaking down. I mean, is it an administrative issue? They can't regulate it, or it's in the public? So.
Well, there are several things, and one of them is it's an administrative issue, it's an enforcement issue. Proving, although people who reverse engineer tend to keep good records of it, because they want to show that's what they did. There are several justifications. The economic justification is that without the law, people are going to do it anyway. And so there's a net no gain. So the question is, in order to bar reverse engineering, you have to show that there's real value there. And there are scholars out there who attempt to make that showing. Another reason for reverse engineering, and this is one I firmly believe in, is that by reverse engineering, you allow for the possibility that things will be improved. Usually if it's true reverse engineering, you're not just copying the exact same thing, you actually make improvements. Because if you're selling the same exact thing, reverse engineering can be an expensive way to do it. There are cheaper ways, for example, doing it from scratch. Of course, now the person who reverse engineers has a choice. Is it cheaper to design myself, or is it cheaper to reverse engineer? And that kind of leads to the third one, which is a competitive thing. Sometimes it's impossible to get into a market and to compete unless you have the ability to reverse engineer. These video games are an example. If a company won't license to you, what choice do you have if you want to sell video games for a particular system than to reverse engineer? And then the question is it cheaper to reverse engineer, or is it cheaper to pay the royalty? And if it's cheaper to reverse engineer, then the argument is that there's an anti-competitive effect of that royalty. And once again, there's a dispute about that, about whether you can force people to agree not to reverse engineer. There was a case recently related to World of Warcraft where they reverse engineered the main server, the world server that the game logs into, and the argument was, well, you agreed not to reverse engineer that with your little shrink wrap license that came with it. That's a good question, and reverse engineering is one of the more and it's interesting because I give it like a paragraph in the article, perhaps because it is one of the more hotly debated things. The reason I only give it a paragraph is I'm looking at why we have the rule or why it should be justified, and the way I come down is people are going to do it anyway, so you have to show some real benefit to blocking it, and I haven't seen that. I haven't seen anybody really show that convincingly yet. Yes?
In a case, so you mentioned trade secrets are state law, and it's not considered property, and there's basically three different ways in which jurisdictions have interpreted trade secrets. So if say there's a trade secret violation in a different state, and then how would we know which trade secret, uniform flavor A, uniform flavor B, or restatement? Because it's not obvious, so you can't say it's incorporated in whatever company, or is it the state in which the act or which the violation occurs, or?
Well, I think you'd have to take conflict of laws to figure that one out. But I think the gist is it's probably going to be one of two things. And there's a dispute about this. There are like competing trade secret cases, etc. It will probably be the state where the wrongdoing occurs, because theoretically that's the rules that you would have to live by. It could possibly be the state of residence of the person doing the wrongdoing. So that is, if you're a California company and you go to the state for the sole purpose of obtaining information, then you can then you might apply one or the other laws. For example, there's a case out of the Second Circuit called Autodesk that actually applies California law, because I think the wrongdoing occurred in California law, but the guy was resident in New York. I forget what the reason was, but there's a conflicts of laws. That really will only affect things on the margin. For the most part, if there's a trade secret misappropriation, if it's really a misappropriation, it's going to be, under any law you apply, it's going to be found liable. It's only, only on the very borderline case where it's like customer information that you can kind of get from a phone book, and maybe they did or didn't, that you really have to hit hard the differences between the states, and the differences are not going to come into play in the bulk of the cases. Yes?
There is another researcher by the name of David Lamont, who's affiliated with Stanford's Internet Society.
Yes, I had dinner with him last night.
Oh, cool. So you probably talked about this quite a bit, because he has a paper out right now which has to do with trade secrecy and public infrastructure.
Right. I haven't read it, but I know he's publishing that.
And so I'm wondering, what is your take on what could be apparent conflicts between the public interest and trade secrecy, particularly if we're talking about issues of use of technology that's protected under trade secrets for public needs, such as voting machines or public wireless networks and that sort of thing?
Well, that's a very good and interesting question. And I think you have to look back to the Ruckelshaus case, and that's where I get my view, which was this case that said if you have trade secrets and there can be a taking. And what's often not discussed about that case was a ruling that said, look, if the government sets a rule that says if you want a certain type of protection, you've got to give up your trade secret right. You've got a choice. You either give up your trade secret right and get that government benefit, or you don't. And they ruled that was not a taking. What they ruled was a taking was that they changed the rules. They submitted the information thinking it was going to be confidential, and then the government said, okay, now we're going to make it public. And they said, wait a minute, well, that was not the deal. And that was the taking. But they said, as to future ones, where the rule is clear, you have a choice to make. So that's where I fall. Hopefully that answers your question. That's where I fall, though, on the public use. If the government says, we are going to take your secret information and use it, and they do it, and they do it without consent, my view is that's a taking, and then they're entitled to whatever the damages or value of the secret is for publication. But if the rule is, if you want the benefit of some public contract, and that contract requires you to reveal, requires you to take, Microsoft, if you want to sell to the federal government, that means you've got to make your source code open source. My view of life is Microsoft's got a choice. They either don't sell to the government, or they sell to the government and make their source code open source. And anybody could do that, really, with enough bargaining power. And in fact, some companies do. There are rules where some companies will buy some of our clients who are startups, but they make them put the source code into an escrow. That's arguably a waiver of trade secret rights, but there are a lot of rules that keep that from getting out, and non-disclosure agreements. But I view the government as no different than any other customer in that way. If the government requires you to give up your trade secret rights for a benefit, you got a choice to make. Does that answer your question?
So you're basically putting the onus on the government to be forward-thinking and have it be a sort of contractual obligation at the outset.
Not necessarily contractual. I put the onus on the government of saying, this is what's going to happen to whatever information you submit to us. And I put the onus on the government if they want something if the government wants something that is otherwise not available to it through eminent domain, it should use eminent domain and set a law that if it's going to destroy the trade secret, then fine, but the government's got to pay for it. But at the same time, if it says if you want the benefit, for, let's say, for public infrastructure, if you want to be our wireless provider, this is the information you have to give to us, A, B, C, D, E. This is what's going to happen to the information. I think the government has to do that, and I think by and large they do. Of course, I haven't read his article. Maybe they don't, and I'm just wrong about that. But from what I've seen of detailed proposals, the default usually is if you give it to us, it goes into a public file, and that's the end of it. And a lot of companies will shade what they give up in a proposal because of that. They won't disclose information. But maybe that's asking too much of the government. But they're big boys and girls. So I think those in the government can take steps. Any other questions? Okay, well, I guess we have 10 minutes left, so if you want to come up afterward and ask anything about this or otherwise, I'll be around. And otherwise, thank you very much for your attention today.